I was still holding a white rose over my mother's grave when my husband leaned close and whispered that his attorney needed to review the estate documents. The air in Charleston was thick with humidity, the kind that presses against your lungs and makes black funeral fabric cling to your skin. The scent of lilies and freshly turned soil mixed in a way I will never forget. People were still standing around the casket, offering soft condolences, squeezing my hands, telling me my mother had been a remarkable woman. And Ryan chose that moment. His hand rested lightly at my back. A picture of support. If anyone had been watching us, they would have seen a grieving couple holding each other upright. But his voice was calm, measured, almost practical. "We should go over the will soon," he murmured. "There might be complications." Complications. I remember blinking at him, not understanding. My mother had been gone less than an hour. I had just watched them lower her into the ground. I thought the hardest part was over. I was wrong. 2 weeks later, a man knocked on our front door just after 10 in the morning. I was still on leave from the hospital, moving through my days in a fog of paperwork and condolence cards. When I opened the door, he asked for Olivia Carter. "That's me," I said. "You've been served?" The envelope felt heavier than it should have. Ryan Carter versus Olivia Carter. Petition regarding inheritance. Claim under marital property laws. Allegation of undue influence. My husband was suing me. I read the words again, slower this time, as if they might rearrange themselves into something less absurd. He was challenging my mother's will, claiming I manipulated her during her final months, arguing that the estate, worth several $1 million in rental properties, investments, and her share of a small family business, should be considered marital property. Excluded spouse. Undue influence. Financial fairness. The phrases blurred together. My mother, Margaret Hale, was 81 when she passed, a retired accountant who tracked every expense in neat spreadsheets. She owned 3 coastal rental homes and had spent decades building quiet security. She didn't believe in flashy wealth. She believed in stability. She left everything to me, her only child. That evening, Ryan came home like nothing had shifted. He loosened his tie, set his keys in the ceramic bowl by the door, and asked if we were out of almond milk. I was sitting at the kitchen table with the lawsuit papers spread out in front of me. "You filed this?" I said. He didn't deny it. "It's not personal, Liv," he replied evenly. "It's financial protection." I stared at him. "You're accusing me of manipulating my dying mother." "I'm questioning circumstances," he corrected. "You handled her care. You managed her appointments. You were around her constantly. It's reasonable to ask whether she was influenced." Influenced. I felt something inside me go very still. "She updated her will with her attorney," I said. "Privately, and I was excluded," he answered. "After 11 years of marriage. That's not exactly fair." "Fair." My grief twisted into something sharper. "Under marital property laws," he argued, "inheritance that impacts a household of this size affects both spouses." He said he deserved security, that we were a partnership. It sounded almost logical when he framed it that way. Except for one thing. He had filed the lawsuit without telling me. The next morning, I logged into our joint bank account and saw that he had already transferred funds out for legal expenses. Preparation. This wasn't an emotional reaction. It was strategy. I contacted a probate attorney recommended by one of my mother's old colleagues. His name was Samuel Briggs. Calm voice. Steady questions. "Inheritance is generally considered separate property," he told me, "but litigation can complicate even straightforward matters." He asked if Ryan had ever shown unusual interest in my mother's assets before her death. I almost said no. But then I remembered a dinner 6 months earlier. The 3 of us sitting at my mother's oak table. Ryan asking detailed questions about restructuring her rental properties, about forming a limited liability company, about long-term asset positioning. At the time, I thought he was being helpful, curious, engaged. Now, sitting across from Samuel with lawsuit papers in my bag, the memory felt different. more deliberate. That night, Ryan fell asleep beside me as if nothing had cracked open between us. I lay awake staring at the ceiling fan turning slowly in the dark. My mother used to say, "Security isn't about money. It's about not being cornered." For the first time in my life, I felt cornered. And I was beginning to suspect that this inheritance battle hadn't started at the courthouse. It had started long before my mother was buried. Ryan was already dressed for work when I walked into the kitchen the next morning, as if lawsuits were part of our normal routine. He stood at the counter stirring his coffee. Scrolling through emails on his phone, sunlight streamed through the blinds. Cutting across the table where the inheritance lawsuit papers still lay, "Did you sleep at all?" he asked without looking up. "You're accusing me of undue influence," I said instead. He sighed, finally meeting my eyes. "Liv, it's strategy. My attorney said we need to question the will formally if we're going to assert marital property rights." "Rights," I repeated. "We've been married 11 years. Your mother's estate changes our financial position entirely. I deserve protection." "Protection? You could have talked to me," I said. "I tried," he replied. "Every time I brought up finances, you shut down." I felt my pulse rise. My mother was dying. And that's exactly why things needed clarity, he shot back. When large assets transfer, people get excluded. That's not how marriage works. Excluded. He spoke like a man denied entry to something that belonged to him. That night, his parents invited us over for dinner. His mother set the table like it was Thanksgiving. All polished silver and folded napkins. His father poured wine and asked about the weather before anyone mentioned the lawsuit. "We just want you two to work this out," his mother said gently, though her eyes stayed fixed on me. "Marriage is a partnership. An inheritance of that size affects both spouses." His father added, "It's reasonable to want fairness." Fairness, again. "So suing me is fairness?" I asked quietly. Ryan stiffened. "It's clarifying legal standing." "You were left out," his mother said. "That has to hurt." I stared at her. My mother had been meticulous, disciplined. She updated her will with legal counsel. She chose to protect her estate as separate property. But in that dining room, I felt like the selfish one. On the drive home, Ryan broke the silence first. "You're acting like I'm the enemy. You filed a lawsuit against me," I said. "I filed to protect what's ours." The next morning, I checked our joint account again. Several $1,000s were gone. "For legal fees?" he said when I confronted him. "You moved it without telling me." "It's our money," he replied. "We're in this together." "Are we?" Later that afternoon, I sat in Samuel Briggs' office again. He reviewed the petition carefully, tapping the pages with a pen. "They're asserting that the inheritance may have become marital property depending on how funds are handled," he explained. "Have you deposited any estate distributions into joint accounts?" "No," I said quickly. "Good. Keep it that way." He paused. "Did your husband ever encourage you to merge accounts or simplify financial structures related to your mother's assets?" The question lingered longer than it should have. There had been small suggestions over the years. Ryan proposing that we consolidate savings for efficiency. Ryan offering to help manage paperwork when my mother's health declined. Ryan saying it would be easier if everything were under one umbrella. At the time, I saw it as teamwork. Now it felt like positioning. 6 months before my mother died, we had dinner at her house. I could see it clearly. The three of us around her oak table. Ryan asking about rental titles. About whether forming an LLC might be smart. About future asset transfers. My mother had listened calmly. Then said, "Everything is structured appropriately." Her tone wasn't defensive. It was final. I remember the way Ryan smiled after that. "Too quickly." And changed the subject. Back in Samuel's office, I felt a slow chill. He asked detailed questions. I admitted. Samuel nodded thoughtfully. "They'll try to build a narrative around undue influence," he said. "We counter with documentation." As if on cue, my phone buzzed. A message from a mutual friend. Hey, saw Ryan's post? Everything okay? I opened social media. Ryan had written something vague about protecting your future when trust shifts. He wasn't just filing an inheritance dispute. He was shaping a story. That night, I searched through old emails between him and my mother. Polite messages at first, then increasingly specific questions about property values, about projected rental income, about potential restructuring. He had been gathering information long before the lawsuit. I lay in bed beside him, listening to his steady breathing. The man who claimed this wasn't personal had already positioned himself financially. The next day, Samuel asked something that made my stomach tighten. Did you and your husband ever sign a postnuptial agreement? The memory surfaced slowly. 5 years into our marriage, after one of Ryan's investments collapsed, we had signed paperwork. He said it was temporary, a safeguard, a formality to reassure lenders. I hadn't read every page. I had trusted him. Yes, I said quietly. We did. And as I said it, I realized something. If this inheritance lawsuit was built on entitlement, there might be a document with his own signature that said otherwise. Samuel's assistant placed the certified copy of our postnuptial agreement on the desk between us like it was something fragile. The paper looked ordinary. Cream-colored, official stamp in the corner. My name beside Ryan's on the final page. I felt my throat tighten. We both had independent counsel. Samuel said, adjusting his glasses as he scanned the first few pages. That's important. 5 years ago, Ryan's startup investment had collapsed almost overnight. I still remembered the tension in our house then. The late-night phone calls. The numbers scribbled across legal pads. He told me creditors needed reassurance that our personal assets were insulated. It's just precaution, he said at the time. This protects both of us. I had signed without hesitation. Samuel turned another page. Here, he said quietly. He read aloud. All inheritance received by either party shall remain separate property and shall not be classified as marital property under any circumstances unless expressly retitled in writing. I felt air return to my lungs. So the estate is protected, I said. On its face, yes. He continued reading. There's an amendment. I leaned forward. The amendment was attached as an addendum, dated the same month, initialed by both of us. It referenced anticipated future inheritance from Margaret Hale by name, my mother. Ryan had known, even then, that my mother's estate would one day pass to me. He can't claim he was blindsided, Samuel said evenly. The language shows clear awareness. A memory surfaced. We were sitting at the kitchen table with takeout cartons pushed to the side. Ryan had flipped through the pages, pointing where I needed to sign. It doesn't change anything, he promised. It's just structure. I didn't read every clause. I trusted him. Samuel's pen paused on another paragraph. This is the critical provision. The amendment contained a liquidated damages clause. If either spouse initiated litigation attempting to claim the other's protected inheritance and failed, that spouse would be financially responsible for attorney fees and predefined damages. I stared at the words. He signed this, I whispered. You both did. My hands trembled slightly. Ryan wasn't just suing me over my inheritance. He might have activated a penalty clause he had forgotten existed. Samuel leaned back in his chair. His attorney may attempt to argue coercion, he said. But the existence of independent legal counsel weakens that claim significantly. What if he says he didn't understand it? Ignorance of a signed contract rarely holds up. A strange calm settled over me. For the first time since being served, I felt something other than fear. But Samuel wasn't finished. I've requested the full probate file for your mother's estate, he said. There's a reference in the will to a sealed supplementary memorandum. Sealed. I repeated. Yes. To be opened in the event of litigation. My pulse quickened. Ryan had filed litigation. If that memorandum contains reinforcement of her testamentary intent, Samuel said, it strengthens your position considerably. That evening, I confronted Ryan. The postnuptial agreement protects inheritance as separate property, I said. And the amendment references my mother's estate specifically. He didn't look surprised. Circumstances change, he replied coolly. Contracts signed during financial crisis aren't always enforceable. You had your own attorney. He shrugged. We'll see how it holds up. His confidence unsettled me. You knew about her estate years ago, I said. You signed acknowledging it. I acknowledged it existed. He corrected. That doesn't mean I agreed to be excluded forever. Excluded. The word again. You filed a lawsuit knowing what you signed. I said. He stepped closer. I filed because I won't be left financially exposed. He said quietly. You're thinking emotionally. I'm thinking practically? Practically. As if my mother's legacy were a line item on a spreadsheet. Later that night, I moved into the guest bedroom. The house felt different. Colder. Every shared object suddenly divided by invisible lines. I lay awake replaying small moments from the past few years. Ryan suggesting we consolidate accounts. Ryan offering to manage paperwork for my mother's rental properties. Ryan asking detailed questions about asset transfers. Patterns. The next afternoon, Samuel called. I reviewed the amendment more closely, he said. The inheritance contest clause is explicit. How explicit? If he proceeds and loses. The financial consequences could be substantial. I thought about Ryan's steady tone at the funeral. His calm insistence that this wasn't personal. If he remembered what he signed, he was gambling. If he didn't, he was about to learn. Either way, the inheritance battle was no longer just about what he hoped to gain. It was about what he stood to lose. The courthouse steps felt steeper than I remembered as I climbed them that morning. Charleston's air hung heavy, pressing against my chest, but my movements were steady. Ryan stood near the entrance beside his attorney. Suit crisp. Posture confident. His parents lingered a few feet behind him, their expressions tight with quiet certainty. If anyone had glanced at us, they would have seen a composed couple walking into a legal proceeding. They would not have seen the fracture. Inside the courtroom, the polished wood reflected the overhead lights. The state seal loomed behind the judge's bench. I took my seat beside Samuel Briggs and folded my hands in my lap. Ryan sat across from me without looking in my direction. Judge Eleanor Whitmore entered with measured authority and called the room to order. Ryan's attorney rose first. He spoke smoothly, deliberately. He described my mother as elderly and vulnerable in her final months. He emphasized my role in managing her medical care. He used the phrase undue influence more than once. It is our position, he said, that Mrs. Hale's will should be examined in light of the circumstances surrounding its execution. He framed Ryan as a devoted spouse unfairly excluded from a significant inheritance. He referenced marital property laws. He spoke of fairness, partnership, and financial expectations in long-term marriages. I sat still, feeling each word like a small incision. When it was Samuel's turn, his voice was calm. The decedent's testamentary intent is well documented, he began. We have a valid will executed with independent legal oversight. We have a postnuptial agreement explicitly protecting inheritance as separate property. Ryan's attorney objected immediately, arguing that the agreement was signed during financial distress and should not automatically be considered enforceable. Judge Whitmore raised a hand. The existence of independent counsel will be relevant, she said. Samuel then mentioned the amendment referencing anticipated inheritance from Margaret Hale by name. The courtroom shifted slightly. Ryan leaned toward his attorney, whispering. Samuel continued. The will references a sealed supplementary memorandum, he said, to be opened in the event of litigation. Ryan's attorney objected again. Surprise evidence, he said sharply. It is referenced within the probate filing, Samuel replied evenly. Triggered by the plaintiff's own lawsuit. Judge Whitmore requested the estate file. The room fell silent as she reviewed the documents at the bench. The only sound was the soft turning of pages. Ryan's confidence seemed intact. But I noticed the tension in his jaw. After several long minutes, the judge looked up. I will review the sealed supplement in chambers, she said. Court will recess briefly. In the hallway outside the courtroom, Ryan approached me. "This doesn't have to escalate," he said in a low voice. "You filed the lawsuit," I replied. "We can settle," he pressed. "Split the estate. Avoid dragging this through more hearings." His tone was controlled, but there was urgency beneath it. "I'm not negotiating my mother's will," I said quietly. He exhaled sharply. "You're being stubborn. I'm being consistent." He studied me for a moment, as if recalculating. When we returned to the courtroom, Judge Whitmore resumed her seat with a different expression, more focused, less neutral. "The sealed memorandum," she began, "contains material directly relevant to this dispute." Ryan's attorney straightened. "It appears the decedent anticipated potential legal challenges to her estate." The judge continued. "The document references her cognitive clarity and her desire to protect her assets as separate property." My pulse pounded in my ears. She glanced toward Ryan. "Mr. Carter," she said, "were you aware of the postnuptial amendment referencing inheritance contests?" Ryan hesitated. "Yes," he answered carefully. "But circumstances changed. Did you review that amendment prior to filing this lawsuit?" she asked. A pause. "I don't recall reviewing it recently," he said. The hesitation lingered. Judge Whitmore made a note. "This court will schedule a full evidentiary hearing," she said. "We will examine the validity of the will, the postnuptial agreement, and the contents of the sealed memorandum in detail." She paused, then added, "Based on preliminary review, the matter may not proceed in the manner the plaintiff anticipates." The words hung in the air. Ryan's shoulders stiffened slightly. For the first time since the inheritance lawsuit began, I saw uncertainty flicker across his face. As we stood to leave, Samuel leaned toward me. "If the supplement contains what I suspect," he murmured, "this could trigger consequences beyond dismissal." Outside, the sun felt harsher than before. Ryan did not walk beside me down the courthouse steps. He walked ahead, and for the first time, I wondered if he understood that by suing me for my inheritance, he might have just set something in motion that would turn against him. The courtroom was quieter the day of the evidentiary hearing, but the tension felt heavier. Ryan sat straighter than usual, jaw set, hands folded too tightly on the table. I could feel the weight of what was coming before anyone spoke. Judge Whitmore called the session to order and began by referencing the sealed supplementary memorandum attached to my mother's will. "The court has reviewed the contents in full," she said. My pulse pounded in my ears. The document included a notarized written declaration from my mother, executed 6 months before her death. It also included a cognitive evaluation conducted by her physician confirming she was of sound mind at the time she finalized her estate planning. Ryan's attorney shifted in his seat. Judge Whitmore continued. "The declaration explicitly affirms Mrs. Hale's testamentary intent and her desire that her estate remain the separate property of her daughter." The word separate seemed to echo. Then, Samuel requested permission to play a portion of the recording referenced in the memorandum. The judge nodded. A faint crackle came through the courtroom speakers before my mother's voice filled the room. "Steady. Calm. Clear. If you are hearing this," she said, "it means someone has chosen to challenge my will." My throat tightened. "I have made my decisions deliberately," she continued. "My estate is to remain my daughter's separate property. It is not to be subject to any marital claim. I have felt subtle pressure regarding my assets, and I want it clear that no such pressure influenced me." The courtroom was silent when the recording ended. Ryan stared straight ahead. His attorney cleared his throat. Samuel rose slowly. "Your Honor," he said, "we would also like to introduce additional documents uncovered during discovery." He submitted printed emails and financial records. One was a loan application Ryan had filed nearly a year before my mother passed. In it, he referenced anticipated access to inheritance assets as part of his projected financial standing. Another was an email chain where he asked my mother detailed questions about transferring her rental properties into an entity he would manage. The dates were undeniable. Judge Whitmore reviewed the documents carefully. "Mr. Carter," she said, "were you aware of the postnuptial amendment protecting inheritance as separate property when you filed this action?" Ryan hesitated. "I was aware of the agreement," he said cautiously. "And were you aware of the liquidated damages provision tied to unsuccessful inheritance contests?" She pressed. His attorney objected, but the question remained. "I didn't review every clause recently," Ryan admitted. The admission felt like a crack in glass. Samuel stood again. "Your Honor, the amendment clearly states that initiating litigation to claim protected inheritance, if unsuccessful, triggers financial penalties and attorney fees." Judge Whitmore nodded slowly. "The court will consider enforceability," she said. She then turned back to Ryan. "You referenced anticipated inheritance in a loan application months before Mrs. Hale's passing. How do you reconcile that with your claim of being blindsided by exclusion?" Ryan's composure faltered. "That was hypothetical planning," he said. "Planning," the judge repeated. The word lingered in the air. "For the first time since this inheritance battle began, I no longer felt like the defendant. I felt like a witness to something unraveling." After a brief recess, Ryan approached me in the hallway. "This has gone too far," he said under his breath. "You filed it," I replied. "We can withdraw," he said. "Walk away from this before it escalates." "It already escalated," I answered. His eyes flickered, not with anger this time, but something closer to fear. When we returned to the courtroom, Judge Whitmore addressed both parties. "The court finds strong preliminary evidence supporting the validity of the will and the decedent's testamentary intent," she said. "The postnuptial agreement appears facially valid." She paused. "If the plaintiff's claims are dismissed, the enforcement of the liquidated damages clause will be considered." Ryan's attorney shifted again, whispering urgently. Judge Whitmore continued. "The matter will be taken under advisement. A written ruling will follow." The gavel struck lightly. As we stood, I realized something profound. This inheritance lawsuit was no longer about what Ryan hoped to gain. It was about the consequences of what he had already set in motion. Outside the courthouse, the air felt different. Ryan didn't speak, and for the first time, I could see it clearly. He hadn't just challenged my mother's will. He had challenged a contract with his own signature on it. And now the cost of that decision was about to come due. I woke before sunrise the morning the ruling was scheduled to be issued. The house was quiet in a way it had never been before. Ryan had been sleeping in the guest room for weeks now, though neither of us had said the word separation out loud. The silence between us felt heavier than any argument. I made coffee and stood at the kitchen window, staring out at the pale light settling over the neighborhood. A year ago, this kitchen had been where we laughed about small things, where we planned vacations, where we signed paperwork I barely read. Now it felt like neutral ground in a war that had already changed us. At the courthouse, the hallway outside the courtroom was nearly empty. No cluster of family members this time. No whispers from spectators. Ryan stood a few feet away, hands in his pockets, eyes fixed on the floor. His parents were not there. He looked tired. When Judge Whitmore entered and called the room to order, I felt a stillness settle inside me. Not fear, not hope, just readiness. She began by summarizing the findings. "The court finds that the will executed by Margaret Hale is valid," she said clearly. "The evidence establishes clear testamentary intent and confirms that the decedent possessed full cognitive capacity at the time of execution." My chest tightened, but I kept my face steady. "There is no credible evidence supporting the allegation of undue influence," she continued. "The plaintiff's claim is therefore dismissed." Ryan's attorney shifted beside him. The judge did not pause for long. "The court further finds that the post-nuptial agreement and subsequent amendment were executed voluntarily, with independent legal counsel for both parties." She lifted a page from the file. "The amendment explicitly references anticipated inheritance from Margaret Hale and designates such inheritance as separate property, not subject to marital property claims. Separate property." The phrase felt like armor. Judge Whitmore looked directly at Ryan. The plaintiff initiated litigation, contesting protected inheritance despite having executed an agreement containing a liquidated damages provision tied to unsuccessful contests. The words hung in the air. Accordingly, she said, the court finds the liquidated damages clause enforceable. Ryan's posture shifted, almost imperceptibly. In addition, she continued, the plaintiff shall be responsible for reasonable attorney fees incurred by the defendant in defending this action. I felt my pulse in my fingertips. The court also notes the existence of a loan application referencing anticipated access to inheritance assets prior to the decedent's passing. She added, while not rising to a separate claim in this proceeding, it is relevant to the court's assessment of credibility. Credibility. The gavel came down softly. This matter is concluded. For a moment, the room was silent. Ryan's attorney leaned toward him, whispering urgently. Ryan's face had gone pale, the confidence he carried at the funeral long gone. Outside the courthouse, he caught up to me on the steps. Olivia. Wait. I stopped but didn't turn immediately. This doesn't have to end like this, he said. We can work something out. Reduce the penalties. Figure out a compromise. You filed the lawsuit, I said calmly. I was trying to protect myself, he insisted. You know how unstable my finances were after the business collapse. I couldn't risk being left exposed. And so you tried to claim my inheritance, I replied. He ran a hand through his hair, frustration breaking through. You're acting like I committed a crime. You signed a contract, I said. You broke it. He stared at me, searching for something, sympathy, maybe, or weakness. Instead, I felt clarity. The inheritance battle had never been about money alone. It had been about control, about entitlement, about whether I would quietly absorb the narrative that partnership meant surrendering boundaries. I'll be filing for divorce, I said. The words came out steady, almost gentle. His shoulders sagged. You're really throwing away 11 years over this? No, I answered. You did that when you decided to sue me. That evening, I stood in the living room and looked at our wedding photo hanging on the wall, the two of us smiling, unaware of what we would become. I took it down. In its place, I set a framed photograph of my mother standing in front of one of her rental properties, sunlight on her face, pride in her posture. Security isn't about money, she used to say. It's about not being cornered. For the first time since her funeral, I didn't feel cornered. I felt anchored. As I gathered Ryan's remaining belongings into boxes, I realized something else. The lawsuit had not destroyed my life. It had revealed it. And in that revelation, I had chosen myself. The house was finally quiet the night I found the envelope. Ryan had moved most of his things out that afternoon. The closets felt hollow, drawers half empty, the air strangely still. I sat at the kitchen table surrounded by stacks of my mother's paperwork, organizing deeds, insurance documents, old bank statements. That was when I saw it. A cream envelope tucked between two folders, my name written across the front in my mother's steady handwriting. Olivia. No last name. Just Olivia. The date in the corner was 3 weeks before she died. My hands trembled as I broke the seal. The paper inside was thick, familiar. I could almost see her sitting at her dining room table while she wrote it. Glasses low on her nose, pen moving with deliberate strokes. If you are reading this, the letter began. It means someone has challenged what was always meant for you. My throat tightened. She wrote that wealth does not create betrayal. It reveals it. She explained that every clause in her will and trust had been drafted carefully, that separate property protections were not about exclusion, but about insulation, about ensuring that what she built would not be dismantled by pressure, persuasion, or entitlement disguised as partnership. I have sensed, she wrote, questions about my assets that were not rooted in curiosity but in positioning. She never mentioned Ryan by name. She didn't need to. I do not distrust you, she continued. I trust that you will see clearly when it matters. Tears blurred the page, but I kept reading. I structured my estate not because I expect conflict, but because I understand human nature. Security must be defended, even from those who claim to share it. I lowered the letter slowly. For weeks, I had told myself this inheritance battle was about revenge, about winning, about proving Ryan wrong in a courtroom. But sitting there in the quiet kitchen, I understood something deeper. It wasn't revenge. It was exposure. The lawsuit hadn't transformed him. It had revealed him. There was a knock at the door. Ryan stood there when I opened it, hands shoved in his coat pockets. "I just need a minute," he said. I let him in. He stood awkwardly near the living room, glancing at the boxes stacked by the wall. "My attorney says we might be able to negotiate the penalty amount," he said. "If you're willing." Accountability now had a dollar figure attached. "You signed the amendment," I said. "I didn't think it would ever be used," he replied. "That doesn't make it less real." He looked at me differently then. Not angry. Not defensive. Just tired. "I was scared," he admitted. "After the business collapsed, I felt like everything could disappear overnight. Your mother's estate felt like stability. It wasn't yours," I said quietly. He didn't argue. "I thought marriage meant sharing everything," he said. "Marriage doesn't erase boundaries," I answered. He nodded slowly, as if hearing that for the first time. "I don't know how we got here," he said. "I do," I replied. "We got here when you chose to sue me instead of trust me." He left without another word. I returned to the kitchen and read the last lines of my mother's letter again. Security is not something someone gives you. It is something you defend. If you ever feel cornered, remember that you are stronger than you think. I folded the letter carefully and pressed it against my chest. The next morning, I met with a financial advisor. For the first time in my life, I took full control of every rental property, every account, every document. I restructured the estate into a new trust to protect future generations. I closed joint accounts. I separated everything cleanly. I replaced the wedding photo in the living room with a framed picture of my mother standing in front of one of her properties, sunlight catching her hair. When I looked at that photo, I didn't see money. I saw foresight. I saw strength. I saw a woman who understood that love without clarity can become vulnerability. That evening, I visited her grave again. The air was cooler this time. "I understand now," I whispered. "Not just the clauses, not just the legal language. I understood the lesson. She hadn't just left me an estate. She had left me the courage to protect it." I stood at my mother's grave again on a quiet Sunday morning, holding the same white roses I had carried the day we buried her. The air felt different now, lighter. The sky stretched clear above the cemetery, and the wind moved gently through the trees instead of pressing down on my chest. The first time I stood here, I thought the hardest part was over. I had been wrong. "I handled it," I said softly, looking at her name etched into the stone. "Your will held." There was no dramatic swell of emotion this time. No collapse in my knees. Just a steady sense of closure. The inheritance battle was over. The lawsuit had been dismissed. The penalty clause enforced. The divorce papers were filed. Ryan had moved into a small apartment across town. We spoke only through attorneys now. The financial consequences of his decision were real. The court ordered attorney fees. The liquidated damages clause he had signed years ago without reading closely enough. Karma hadn't arrived with thunder. It arrived stamped and filed. I walked back to my car slowly, remembering that first whisper at the funeral, his calm voice saying there might be complications. There were complications, just not the ones he expected. In the weeks that followed the ruling, my life didn't explode into something new. It unfolded quietly. I met with my financial advisor and restructured everything under a revised trust. The rental properties remained intact. I began visiting each one personally, introducing myself to tenants who had only known my mother's name on lease agreements. They were surprised to see someone my age managing the properties. I was surprised too. For the first time, I wasn't just the beneficiary of an estate. I was its steward. I took a financial planning course at the community college on Tuesday evenings. I learned to read balance sheets the way my mother once did. I asked questions I used to avoid because I trusted someone else to handle them. Trust? That word felt different now. Trust is not blind faith. It is informed choice. At home, the living room no longer held our wedding photo. In its place stood the framed picture of my mother in front of one of her properties, sunlight catching her face. Some nights I would sit on the couch and look at it, replaying everything that had happened. The shock of being served. The humiliation of sitting in a courtroom while my husband accused me of undue influence. The moment her voice filled the courtroom speakers. Steady and unmistakable. The judge's calm declaration that her testamentary intent was clear, and the subtle shift when I realized the tables had turned. Revenge had never been about destroying him. It had been about defending what was mine. I had thought the inheritance was the center of the conflict. It wasn't. The real battle was about autonomy. About whether marriage meant dissolving boundaries. About whether partnership meant surrender. Ryan had told me he filed the lawsuit to protect himself from financial instability. Maybe he believed that. But protection built on entitlement always collapses. A week after he moved out, he called me once more. "I never meant to hurt you," he said. "I know." I replied. He had meant to secure himself. He just hadn't expected resistance. After we hung up, I didn't cry. I walked into the kitchen, opened the drawer, and reread my mother's letter one more time. Security is not something someone gives you. It is something you defend. I finally understood what she meant. Losing her was devastating. But losing the illusion of my marriage was transformative. The inheritance battle forced me to confront something I had avoided for years. I had mistaken harmony for safety. Safety comes from clarity, from documentation, from knowing exactly where your boundaries stand. If you've ever faced a family lawsuit, an inheritance dispute, or a betrayal that came from someone you trusted, you already know how isolating it can feel. It can make you question your memory, your judgment, your strength. But here is what I learned. Legal literacy is not cynicism. Financial boundaries are not selfishness. And protecting your legacy does not make you cruel. It makes you prepared. I used to think stories about inheritance battles were dramatic exaggerations, something that happened to other families. Now I know better. If this story resonated with you, I'd truly love to hear from you. Have you ever been involved in an inheritance conflict or a family dispute that revealed someone's true character? What would you have done in my place? Share your thoughts in the comments. Your experiences matter more than you realize, and someone reading them might feel less alone because of you. And if you want to hear more real-life stories about betrayal, justice, family drama, and women reclaiming their power after everything seems to fall apart, stay with this channel. Subscribe so you don't miss what comes next. Because sometimes the hardest battles aren't about money. They're about choosing yourself. And once you do, everything changes.